I'd like to introduce two folks who are gracious enough to offer their talents for the next hour. And that is Brent Pattison from Team Child, right? Got that? Okay, and John Parbo from the Northwest Justice Project. And if you can give them a big hand, they're doing us a big favor by being here today.
Can you hear me? Okay. So we've had lunch, we've had a little door prize, we're hipped up. Nobody wants to be outside where it's sunny and nice on Friday afternoon. Come on, Brent, you don't get to sit down. What we have is an hour. Our goal is to talk to you in that hour about two primary topics, school discipline and special education. But before we get into the substance of that, Brent, what is Team Child anyway?
So Team Child is a nonprofit organization that provides free legal services, civil legal services, to children involved with juvenile court. And so we have offices in 5 counties in Washington, Pierce County, King County, Snohomish County, Yakima, and Spokane. And we do free civil legal aid for kids involved with juvenile court. And usually that means assistance around education law needs, sometimes public benefits issues. And what we try to do, and the work that we do, is also by helping kids involved with juvenile court access support and services they need, and some of those kids are foster kids, we hope to influence their ability to stay out of juvenile court in the future. So we're sort of trying to team up with public defenders and judges and probation officers and basically help kids kind of avoid coming back and cycling through the juvenile court system.
And Northwest Justice Project, where I work, is a statewide civil legal aid program funded through a combination of federal, state, and local sources. We have a local office in Aberdeen that was just opened within the last month. Sarah Glorian is here with me. Sarah, say hi.
Hello.
So Sarah, if people want to know how to access the services provided by their local civil legal aid program right here in town, how do they do that?
In your materials, there's this document that says Community Resource List. And if you look in the back, on the second to last page, it says Free Legal Advice, Northwest Justice. And if you're talking to people who need assistance, they have to get a referral from our hotline, which is out of Seattle, which is clear, and that phone number is 1-888-201-1014, and it's in your packet. We are a 3-attorney nonprofit law firm here in Aberdeen, and if you know Dr. Forrester, we're in Dr. Forrester's building. And send people our way. Our case acceptance criteria is going up today.
Thanks, Sarah. Well, I work in the Tacoma office of Northwest Justice Project, where among the things I do is represent students and parents in school discipline, special education, and related juvenile court matters. My work is similar to Brent's, but our focus is not solely on kids. We cover family law, housing, public benefits, and children and education issues. So our goal is to talk to you about these two topics, school discipline and special ed. I have a question for you before we start. In either of those topical areas, is there something that if we don't talk about in some detail, it'll have been a waste of time? Any topic in those two things that you want to make sure we cover in some depth that matters to you? Speak up.
Yeah, getting 504 plans for kids that you've adopted or foster kids being turned down from the school districts.
Everybody hear that? 504 plans for students in foster care. Anything else? Going once. Going twice. If you come up with something as we're going through, what I want you to do is to speak up. Wave. If that doesn't work, stand up. Brent and I both prefer questions to occur through the flow of the program if you're comfortable doing that. Is that right? That's right. Okay. Well, without further ado, let's talk about school discipline. So, there are 3 very important things to know about school discipline. The first is that the timelines are very short. If you want to deal with it within the framework that's set up, treat those timelines like they matter. We'll talk more about that. Second, students who are given school discipline, that's suspension or expulsion, always have the right to challenge that punishment and tell their side of the story. The details about how they do that vary a little bit in each setting. And third, the way that occurs is in a concept called due process, which is basically the idea of a hearing in which a neutral person makes a decision based on the stories told by each side. These are the key terms that you find used in any discussion of school discipline. There's the general term discipline, which embraces everything other than suspension or expulsion. Then there's two kinds of suspension and two kinds of expulsion. How many in the room work in the education field? A majority. Many of you already know about this. How many in the room are foster parents or other parents of any sort? Again, a good crowd. Agency types, a smattering. Any other classification I haven't mentioned? Okay. Well, I think that means we can cut this a little bit shorter than we otherwise might, because many of you deal with this in your daily work. But a short-term suspension is 10 days or less. A long-term suspension is more than 10 days, but lasting not beyond the end of the current semester or other grading period, however it's described. Expulsion is you're out of school until we decide to let you back, if we ever do. And emergency expulsion is the immediate removal of someone prior to determining which of the other forms of discipline might be imposed. So Brent, is there anything I've forgotten to say about these things?
Well, actually, let me ask another question to the crowd. Have any of you ever been to a school discipline hearing? Has anybody ever actually...
Some foster parents have been, some teachers have been.
Yeah, so, I mean, usually what these things tell you, what kind of discipline you get, has a lot to do with what kind of hearing you get or what kind of opportunity you have to challenge the discipline. And so, for example, in the context of short-term suspension, the amount of due process is a little bit lower, the Supreme Court has said, because there's not as much of a deprivation of your right to education. And so, in the context of a short-term suspension, the only due process you might get is a chance to talk with the principal about what happened, kind of tell your side of the story, and then kind of see if they'll reduce or modify the punishment in some way. When you get into the longer-term suspensions and expulsions, you have something, it's not like a trial or like a juvenile court hearing, but you have the opportunity to actually go in front of a neutral, kind of impartial hearing officer who will decide what your punishment is, and you'll be able to appeal both whether you did the thing that's led to them taking the disciplinary action against you, and also whether, even if you did it, the punishment's appropriate.
So here's a little look at how quick those timelines can go. When you get the written notice, you have 3 days to decide that you want to ask for a hearing if the action taken is a long-term suspension or expulsion. That's 3 school business days, count them, not 4, 3. That's very fast. If you make that request, you're entitled to a hearing within 3 days of the request. Sometimes there are scheduling issues that make that difficult, and you're free to agree with the school to a different timetable, but you might want to consider that carefully because time is a waste and the student's not in school. So then, within a very short period after the hearing is conducted, you get the decision, and you have 3 more days to decide if you want to go to the school board. And after the school board decision, you have 30 days to go to Superior Court. So that's how fast it can be, and there's a reason for that, because what's at stake is important to both parties. Let's go forward. Now, for an emergency expulsion, this is a situation in which the bad conduct is such that it gives serious concern for whether the school is safe or the student is safe or whether the student should be allowed to remain in school while the decision is made about what the ultimate punishment would be. So the student is immediately removed by the giving of a notice. In this circumstance, the student has 10 school business days to ask for a hearing. So the front end period is a little longer, but after that, it proceeds much the same as before. You can go to the next. Now, let's go back one, because the standard there is what's important. The standard for whether an emergency expulsion is appropriate is whether there's good and sufficient reason to believe that the student's presence poses an immediate and continuing danger, etc. So that judgment is one that ends up getting made usually by the building principal. And that's what's at issue in a hearing on an emergency expulsion, is whether that circumstance truly can be established or not. Let's go forward. So in a hearing, as Brent said, it's not a trial, but there are some rights. It has some formality to it. You get to know what the evidence is against you. You get to be represented by a lawyer if you wish, although you don't have a right to a court-appointed or school-appointed or school-paid lawyer. You get to question and confront witnesses, get to present your explanation if you wish, and you get to call witnesses. So there's formality, but it's not a court hearing. So Brent, who makes these decisions?
School discipline hearing officers, and frequently they're people. Does anybody here from the school district have any familiarity with who their school discipline hearing officer is? Do you guys have anybody know in their own district?
There might even be one in the room. Is there a school discipline hearing officer in the room?
So what the rules say is they can't be. The hearing officer can be an employee of the district, and that might at first seem kind of strange to you, because if they're supposed to be neutral and impartial, then how can they also be employed by the school district? But according to what sort of our state law says about due process, they can be employees of the district, but they can't be someone who is a witness to the incident or anybody who is somebody who imposed the discipline, right? Because we want to get somebody who's outside the process to look at it to make the decision about what to do. Some school districts hire lawyers independently to serve in the role as a hearing officer. Some school districts have assistant superintendents who play that role. There's a lot of different kinds of ways, and a lot of different kinds of hearing officers you might see if you help in a school discipline hearing.
So what we have here are just some thoughts about what to have in your mind when you're confronted with a school discipline issue, particularly if your role is that of parent or foster parent or somebody providing professional services to the student or the family. Things to keep in mind. Act quickly, the timelines are short, and they really mean what they say. Sometimes the notices are confusing. You've already seen the distinction between expulsion and emergency expulsion. If it's a regular expulsion, it's 3 days. If it's an emergency expulsion, it's 10 days. Not everybody makes that distinction, and that's understandable. Sometimes districts take the view that they can punish a student by kicking them out of school for conduct that occurs in a way that has no relationship to the school setting. Now, I'm not talking here about got off at the bus stop and beat somebody up. That's clearly in connection with the school day, passing back and forth. And I'm not talking here about a fight that starts at school and continues into the community. I'm talking here about community misconduct that doesn't have any direct relationship to the school environment. That's a pretty hot topic these days. Many people in the community want the schools to deal with what they view as a problem in the community. And while the schools certainly have a role, the school is not the police force for the community. The school is a learning environment in which misconduct has to be dealt with in order that learning can continue. So if you have a situation in which the misconduct did not occur at or in connection with school, that's another issue to spot. So you end up, here we go. So you end up going through a school discipline hearing decision, and you get a decision that may conclude that the student engaged in the misconduct and that punishment's appropriate. It may uphold the initial punishment imposed. It may change that punishment, may change the length of the suspension. It may uphold the punishment without any change. And you go on through the process, and you end up with a decision that you may like or dislike, depending on your perspective, where you stand, what your role is in the system. A student who has been suspended or excluded from school is not, in our view at least, completely to be forgotten thereafter. And I don't think that's the community view either. I think everybody recognizes that students who misbehave in school and are legitimately removed from school for some period of time are still part of the community. They're still part of our responsibility. And so there are a number of other things to be considered. One is reentry programs. Some school districts have a very formal approach to reentry. They have special alternative schools, or they have a cooperation arrangement with other districts and an educational service district that lets them offer reentry programs or alternative school programs. Be aware of those, find out what exists, find out what their criteria are, and consider seeing if the student you're concerned about can access those. And also keep in mind that the student may be someone with special needs that have not been fully identified or addressed in the educational setting, and that addressing those issues could offer a pathway for additional educational services. So Brent, how is it that having special needs might be important at this stage?
Well, we'll talk more during the time when we're talking about special education about this, but the main point is that for a kid who does have special needs, disability issues, there's a whole nother set of federal rights they have and sort of corollary state rights that protect their right to education, right to evaluation, right to sort of special education if necessary. And so kids, for example, who are out of school and because of discipline that happened, but while they're out of school are identified as kids who might have disabilities, are entitled to have an expedited special education evaluation to see whether or not they have these special needs. And then once they're evaluated and determined eligible, assuming they're determined eligible, it may be required for the school to let them back in and try to figure out a new way to serve them. So for kids that have disability issues, that can present a whole sort of different kind of way to think about having them re-enter school and get back in and get started again with their education.
So any questions or comments about that or anything we've covered so far? Speak up. Let me come to you. Have to say.
Just I wanted to know, what's a 90-day suspension? I mean, how is that? Is that short, medium term, length, or what?
Question is, what's a 90-day suspension? I can't speak to the specific circumstance you have in mind, but the legal structure creates short-term and long-term. I've never seen something that's just called 90 days. Usually one is suspended for either 10 days or less, or somewhere between 10 and the end of the semester. It's possible, I assume, to state it in a specific number of days, but I'd sit down with the calendar and count the number of days between the date the suspension was imposed and the end of the semester, because it's not supposed to extend past the end of the semester if it's a suspension. Now, an expulsion can be for a much longer period of time. Yes?
Should it all be done in writing?
Should it all be done in writing, Brent?
Yes, there should always be written notice of the sort of both the sort of offense that's alleged, the violation of school rules that's alleged, and also the kind of punishment being imposed, as well as information about how to appeal the decision.
Your request for hearing should certainly be in writing.
You're allowed to submit a request. Some districts are allowed, there's a rule that says that districts can choose to accept oral requests for hearing, but you're always better off putting it in writing. Yeah, no question.
Because that way there's not a dispute about whether you asked or when they got it.
I'd like to make one other point, too, about the school discipline hearing process. I mean, one of the reasons that we're talking about this today is that, you know, I guess you probably have already talked this morning about the fact that a rather substantial percentage of kids in foster care are not making it through to graduation. And you know, when we think about ways to help keep kids in school, thinking about these school discipline issues is part of that. So kids get suspended or expelled, they get disengaged from school, there's not always somebody who can help them figure out how to get back in. What we're trying to say today is that as foster parents, as people in the school system, as people who work for DSHS, that you can help kids get back into school, and that school discipline hearings are one way to do it. One other thing that I want to point out is that, you know, you don't, even though you have a right to a lawyer in these circumstances, I wouldn't say that you have to have one. I mean, it helps sometimes. Sometimes the cases are complex or really intense, and it helps to have someone who can sort through the legal issues. But I've seen parents really, and foster parents and caseworkers, really effectively handle school discipline hearings. And sometimes what they end up doing is changing from a more formal hearing into almost like just kind of a meeting of the minds about the kid and what we can do to try to keep them engaged in school and help them do better. And so that's why one of the reasons why it's so important to think about, you know, using these rights as a way to help kids get back into school. And
so
you should
Brent,
feel comfortable.
This whole system of rules and rights and laws seems pretty complex. is there any place parents, foster parents, agency staff can go to get sort of a short version, a guide, sort of a how-to-do-it-yourself, if you will, kind of idea?
So that's what they call, right in the business, a softball question. He threw that. And the reason he threw that is because we at Team Child created a manual that I think some of you may have seen already that's for basically people who are caregivers for out-of-home youth. And it's on our website, which I think was referenced in the first page here, but I'll just say it now. It's www.teamchild.org. And we're actually in the middle of revamping it because there's been some changes in the law. We expect in January we'll have new manuals that we can bring to trainings like this and maybe get to Bruce so that people have access to them. But they're really, it gives you a really easy way. It kind of breaks it down in some pretty simple ways for parents and caregivers, social workers, to help figure out how to do things like a discipline hearing or how to think about attending an IEP meeting and what you should be focusing on. And I think it's really, the people I've talked to about it say that it's very helpful, that it's quite easy to understand, and you can find it on our webpage now, and then, like I said, we'll have hard copies again in January that if people are interested in, just contact us and we'll try to find a way to get them to you.
To come closer to the end of our discussion of discipline, in addition to the alternative programs and reentry programs that we discussed briefly, there's a concept known as readmission. When a student is expelled from school, the way the Washington law is structured, it is by definition an indefinite removal. And so the path back is through a discretionary process called readmission. Washington state law requires that every school district have a readmission policy and that any student who has been expelled may ask for readmission at any time. Many districts don't like that particular feature of it because they'd rather not entertain repeated requests for readmission, one right after the other. But readmission is a very important process, particularly if what's at stake here really isn't did he do it or was it appropriate that he or she be removed from school for this misconduct, but what's at stake really is what's the path back? What's the reconnection opportunity for this student with education? In this state, as you know, we have a fundamental right to education expressed in the state constitution. That tells all of us that the paramount duty of the state is to have and operate a uniform and meaningful system of education. So, okay, here we are. He's been removed. The removal's been upheld or not challenged. He's been out. And the question is, how do you reconnect? Well, a readmission process is not something that is laid out in the same degree of detail, X days, Y days, Z days, as is the expulsion or suspension process. That can make it a little bit of a mystery. But the flip side of that coin is it can also be something you can use to fit the situation and that you can tailor an approach in a way that makes sense given the student's life. So, if you have a student for whom you want to assist in the readmission process, A, get the district's policy by asking them or going to their website if it's posted, and B, proceed in accord with that policy. Usually, you're just asked to say, what's changed? And this is your opportunity to talk about what the student's done, either to accept responsibility in juvenile court or in the community setting, whether counseling's been provided, what services are in place, what's there to wrap around and support this student now that wasn't before, and what's your plan? What's your proposal for the path back? What are the student's particular interests or needs? Is it a vocational focus? Is it a return to, to a particular math program? Whatever it is that pulls the student in, if you can identify something like that. And then you present that. Let's go forward. Well, Brett, I think we've come to your part of the program.
Yeah, that's right. So we're going to talk a little bit about special education now. How are we in terms of time? Where are we in the? Are we about a half? Oh, perfect. All right, so we're about halfway.
We're 2 minutes short of halfway.
So we're trying to squeeze about 2 hours worth of information into an hour for you here. So we're moving a little bit quickly, but you should still feel free to stop us and ask questions as we go through. So if there are only 3 things that you walk away with today from this talking about special education, do we have any special educators in the room? Anybody who's in special education? Great. So you guys jump in when you want to correct me or add something. But the basic three things that I want you to walk away with today are that a problem that interferes with a child or youth's ability to learn may be a disability under the law. And so when we talk about special education, we're not just talking about sort of the diagnosed disabilities that the kid might have, that mental health issues, those kinds of things. We're talking about a specific sort of statutory idea about what it means to need special education. So you should think really broadly about a child's potential need for special education if they're not doing well. The second thing is that every child and youth with a disability that affects learning has a right to instruction that's specially designed to meet his or her needs and in an environment that is as much like a regular classroom as possible. So we have two kind of, maybe at first seemingly contradictory things, right? First is kids get educational services that are really tailored just directly to their needs. But on the other hand, we're trying not to, as a society, pull all the kids that have disability issues out of the regular classes in the mainstream. We want to have kids as much as possible included in sort of regular schools, regular classes. My dad was a principal in a special education program back in it would have been the late 70s and early 80s, and he felt like his whole job, it was a separate school. It was back in the day when they used to put all the special ed kids in separate places, and he felt like it was his job to basically eliminate his job. He wanted to make it so that the kids who were in his program had access to all the same things that the kids at the regular schools had access to, and that they weren't sort of marginalized and pushed out. That's what least restrictive environment means, and we'll talk about that a little more in a minute, and also with this idea of keeping kids in as much as possible in regular education settings. There was one last point there that I didn't cover, and that is that there are also some strict timelines, and you in special education, you teachers and administrators already know this. There's some pretty strict timelines about how quickly they need to do evaluation, when IEP meetings have to happen. I mean, we'll talk a little more about that, but you can look to special education law for help in trying to advance getting help for a kid more quickly using those timelines. So maybe we can move on now to the next.
So Brent, what's the difference between special ed, regular ed, and 504? Are you going to get to that at some point?
Yes, here we go. So this is the universe of education, regular education, and all the kids that we work with that are enrolled in the public schools are entitled to this, right? Whatever that is. Now, it could mean a lot of different things. But, and if you hit the next slide, there's another broader section that's called Section 504. Now, Section 504 refers to Section 504 of the Rehabilitation Act of 1973, I think. And what that law said, it's like a one-sentence law that says, basically, don't discriminate against people with disabilities in programs that receive federal assistance. And even though I think all the local school districts will tell you that they don't get enough federal assistance, they get some. And so that money, because of that, Section 504 applies to schools. And what it means basically is that when a kid does have a disability, they need accommodations at school. And that doesn't just mean, like, for example, having a ramp so that somebody can enter the school in a wheelchair. It also means accommodations for kids who have mental health issues or behavioral problems, trying to help them make it through the school day. So then within 504, then, there's another category, smaller category, of kids who are eligible for assistance under the federal statute, the Individuals with Disabilities Education Act. Now they actually call it the Individuals with Disabilities Education Improvement Act because it was reenacted in 2004. And so those kids are not only kids that have a disability, but that have a disability and need specially designed instruction. So not just sort of some accommodations to help them make it at school, but kids who really need their instruction to be tailored directly to them and to their disability issues.
So Brent, while this helpful diagram's up there, I have a question. I have two neighbors. Each of them has a child which has been diagnosed as having attention deficit hyperactivity disorder. One of them is eligible for special ed. One is not, but has a 504 plan. Can you explain to me how that could be?
Well, what they're supposed to do is look, so ADHD is a really common diagnosis that leads to Section 504 assistance. So what should be happening is the district should look at the kids' sort of ADHD, the sort of level at which it impacts their school, and make a decision about whether the kid needs just some basic accommodations, like maybe some extra time on tests, or help with a little longer on homework assignments, maybe, or shortened assignments. Maybe like if part of their ADHD influences behavior, maybe some kind of behavior plan to help them deal with impulsivity at school. And then if that's not enough, if those basic kind of accommodations aren't enough, then maybe they need broader help under the special education law to sort of get access to specially designed instruction about not only maybe reading or math or writing, but also potentially behavior and other kinds of things to help them improve their performance at school. So it's really, in some ways, it's almost like on a continuum. Kids with 504 issues probably aren't experiencing quite as significant a difficulty as kids with IDEA, kind of special ed plans. If you think about it that way, that might be the easiest way to
Thanks, that was very helpful.
Yeah. So, what is a disability under 504? There is a little bit of a difference between what is a disability under the two laws. Under 504, the definition of a disability is a physical or mental impairment that substantially limits a major life activity. So, for kids, the major life activity that matters for this kind of analysis is school, right? So, if their impairment substantially limits their ability to participate in school, they're eligible under 504. And that's sort of the bottom line kind of test. You can go to the next step. Under the IDEA, there's a much broader set of categories. The statute defines about, 10 or 11 different kinds of disabilities kids might be eligible under, ranging from autism to visual impairment. One of the places where you might see a kid who has ADHD issues is in the other health impairment catch-all provision. So there's one provision that's sort of just supposed to cover a lot of different kinds of medical issues that kids have. But these categories are all defined in the statute, and when evaluation happens, the whole purpose of the evaluation is to see whether any of these areas might apply to a child who might need some extra help.
Before we go on, I think we have a question, and this is from the table at which the 504 item came up. Why don't you speak up? I'll repeat your question for everybody.
Well, I have a child that was being removed from class all the time. Very intelligent, ADHD, ODD, very, very intelligent. I asked for a 504. They said he had no learning, no problems with any of his classes because he's very, no problem with math, no problem with this. But it was the in-class, when the meds wore off. I mean, and he was just being removed from class constantly. And they told me no because he didn't have the actual learning disability.
So let me see if I can repeat that so everybody's in the picture on this question, and then we'll discuss it. This is a student who had several diagnoses, ADHD, obsessive compulsive disorder, but who was bright and did well in school in terms of grade performance, but would get removed for behavior. And when the foster parent or parent asked if he couldn't have a 504 plan, the response, as she understood it, was that his disability didn't impact his learning. Do I have it correct? Well, let's talk about that a little bit, Brad. What's your reaction to that?
Well, my first reaction to it is that in some ways the problem you're talking about is a problem of access, right? If a kid was trying to get into school and was using a wheelchair and there was no ramp, they couldn't get in. Now they might learn just fine, right? But there's no adaptation to the school environment that helps them get into the school in the first place.
So you mean it's the same as if he can't stay in school and keeps getting put out for behavior? It's like not being able to get in the front door to begin with?
I feel like that's my kind of gut first reaction is that if they're not able to get into school because they keep having to be pushed out because the behavior, then really it is influencing a major life activity. It is influencing school and affecting it. I think the other thing is that a lot of kids may be intelligent enough to do quite well in school, but if they don't have the accommodations or support, then they may not actually get the grades or the test scores that we'd hope they'd get because they're missing too much school because of the problems with sort of behavioral problems.
And so, if I'm in a situation like that one described here, and the school has a different view about whether a particular disability impacts my students' learning, and they're not inclined to offer a 504 plan or to provide accommodations of any sort because he gets good grades when he's there, what can I do about that? How do I go forward? What's the next step?
Well, one of the first things is do what probably has already happened, which is to make a referral or a request for evaluation under 504. Because generally speaking, you shouldn't end up being in a position where you're sort of just flatly told, sorry, we won't consider him. There has to be a decision made about whether to evaluate and do more assessment to see whether he needs the 504 plan. And if there hasn't been that step, that's the first thing you need to do, is try to get that assessment done. And that can be done, you know, by the school district or the school in conjunction with maybe the person who's treating the ADHD in the community, getting additional information from the doctor that's treating the kid about how the ADHD impacts school or impacts learning. And so that's the first step. And if you're at loggerheads about that, if you're at a point where, you know, the district's kind of unwilling to do that with you or walk down that road with you, there's also under 504 the opportunity for dispute resolution. And dispute resolution can mean asking for a hearing. It can mean doing mediation with the district. It can mean just having a meeting about it. But there are multiple levels of sort of dispute resolution you can do to try to get the help you need.
And could I find out how to pursue dispute resolution by reading the helpful chapter in the Team Child Manual on this subject?
Yes. So you could look at our manual. We talk about some of the steps you can take. Also, the U.S. Department of Education's Office for Civil Rights, their whole mandate in Washington and the office here is to look at cases of, you know, at least part of their mandate, I should say, is to review 504 kind of issues and complaints from parents about school districts, and to work with school districts to try to figure out solutions when 504 is at issue and there's a dispute. So you can look at the manual, you can talk with people at OCR, the U.S. Department of Education. I think those contact numbers are in the manual that we use. Yeah.
Hi. Do you send out representatives like our local chapters of PAVE does? Parents or Violent Education, do you send out representatives to meet with the district?
Yes and no. We do in cases that are in the counties we're in. And so we're only in 5 counties, unlike PAVE, which actually is in many of the counties in Washington. And also, I should say, Treehouse. Is there anyone from Treehouse here? Yeah, I mean, you know, the Treehouse folks now are statewide, and that's fabulous. I mean, they actually are really good resources. I talk a lot with Phoebe. They're one of the people that sort of runs their office, and they actually probably could come up here and do this training for you. They know a lot about special education law, about 504, and really, I think, are good advocates for people in the community, especially in places where there's not access to, you know, lawyers as easily. Yeah.
But that phone number that Sarah gave you, that you find on the next to the last page of the buff-colored resources compilation in your notebook, that number will give you access to someone who can discuss the issue you identify with you, and if it appears that you're at the point in the dispute where you do need direct legal assistance on the problem, if you or the person you're calling about qualifies financially, you can get referred to the local office of the Northwest Justice Project or other programs that can provide direct assistance. Yes, there was another hand right here.
I want to know, like with 504, I have a child that was born premature and she does have problems in doing some of her schoolwork. She was on the 504 for a short time when she was in 8th grade. Do they have to be redone every year? Does that say she is entitled to have it?
I'm going to have to ask you to repeat that. One of yours weren't good enough to hear. So.
Yeah, I have a child that was born premature. She was on the 504 plan. She's a sophomore in high school now, a couple years ago. And now they're saying that she's not qualified, but she's having trouble, like, almost flunking 2 classes. And, like, the IEPs, I know they have to be redone every so often. Do you have to keep going back in every year to get 504 done?
That's a really good question. You don't necessarily have to go back in every year. It should continue from year to year depending on, you know, the kid's needs. But like the IDEA, the sort of federal regulations that implement 504 say that that sort of 504 plan should be reviewed, and that one way to review them is to follow the sort of the IDEA procedures for every 3 years doing a new assessment and kind of looking. And so the districts have a general obligation to reassess kids to see whether they continue to need services or whether maybe they might need more services or more support. And it's in that process then that they should be thinking about how the 2 classes that your child was failing, how that impact, whether that's a substantial enough impact to keep doing the 504 plan. And so the better connection you can draw between the academic challenges she's having and the sort of disability issue she has, the better chance you have of keeping that 504 plan, I think.
There was another question right here.
I appreciate having the website, but did you bring in a handout or anything from Team Child?
No, so that's a good, so let's segue into this slide. So because the law has changed so substantially in special education, not in 504, but in special education, we are redoing a big portion of the sort of handouts that we have, and we're really not going to have them done and updated until probably December or January. If you want, I mean, I really encourage people to call me, though, and I think my contact info is on the first page of this, but I'm happy to, give it to Bruce or other people to hand out to folks, or just look on our website. You can contact me by using that. And we'll get stuff to you. If what you need are materials, we're happy to provide them. It's just that we're kind of struggling to get through all the changes and make sure to update everything so that it's accurate again, since it changes. Yeah.
Would you just repeat the website?
Yeah, www.teamchild, TEAMCHILD.org. So so that covers the fact that we've had this big change. One interesting point in terms of how slow things change and move. So the law was changed in 2004, went in effect right away, pretty much, compared to the last time they reauthorized it. And then it wasn't until just this summer that the state changed all the state rules to comply with the new law. And so we're really talking for a good 2.5-year period there. There was some differences between federal and state law, and there still are a few, because the state decided to sort of keep in some protections that the federal government was willing to kind of push aside. So things have the change has been really slow, and there were some fairly dramatic changes. So the key thing is to sort of stay tuned for updates to the manual, and I'm happy to talk about some of the specific changes as we go through. So this is one of the things that's really nice about Washington compared to the rest of the country right now. Because it used to say in the federal law that basically anybody could make a referral for special education. The new law says that really it's only school officials and parents that can make a referral for special education. Washington decided not to follow that rule. They said, wait a minute, we have a lot of other people, like the people in this room, that know a lot about kids, that want to be able to help and make referrals in these kinds of cases. And so they decided that anybody really can make a referral for special education in Washington. That's still true. Evaluation must be in all suspected areas of disability. So, for example, if you have a kid with ADHD, but you also suspect a learning disability, you don't just evaluate for the learning disability, right? You evaluate in all the different areas that you think the child might be eligible. So you want to have the evaluation be as broad in scope as possible. And then here's a great other piece. You have a right to an independent education evaluation at school district expense if the evaluation the school district does isn't sort of broad enough in scope or doesn't cover all the things that it ought to cover, or comes to a conclusion that you disagree with. Now, it's not quite as easy as that, because it's possible that the school district might disagree with you about whether the independent evaluation is a good idea, and then sometimes you have to battle it out in front of a hearing officer to see whether it needs to be done or not. But basically, if you ask for one of those kinds of evaluations because you disagree with the district's eval, then the district has 15 days, I think calendar days, I think, to decide whether or not to have an argument with you about it. And if they don't, then you can have somebody outside the district take a look at it. Sometimes that can be a very helpful way to settle a dispute, because if there is a dispute about whether the kid's eligible or not, or what the kid's needs are, having somebody outside take a look at it is something maybe that can help both parties agree on what to do next.
Well, Brent, I have a question. If I have a doctor who's treating my student, and the doctor says that the student has X and needs Y, why doesn't the school just go by that?
Well, the school has an obligation to do the special ed evaluations, and also an obligation to consider other evaluations by other people working with the kid. But the doctor's evaluation on its own probably isn't enough to actually decide that the child needs special education or even Section 504 help. There still is, the district still has to kind of review it and look at what kind of support the kid might need, whether they meet the requirements of, or the eligibility requirements for the IDEA or 504. So that's still, they still have to go through that process. So who in the room has heard of FAPE? Anybody? Yes, great, a lot of people. So FAPE stands for Free Appropriate Public Education, and this is an area where There's not a lot of guidance from the courts. Basically what the Rowley case says, and that's the sort of seminal Supreme Court case about special education law, is that a child's right to a free or appropriate public education means that kids are entitled to meaningful educational benefit, to get an education that gives them some meaningful educational benefit. Now, does that mean that they get the gold standard of educational service, that they're required to maximize the child's potential? Well, the case law says no. It says that what the IDEA creates is a floor of sort of benefit that a kid's supposed to be able to get. And so one reaction that some states have made to that, Washington hasn't, but some states have said, well, you know, creating a floor is not enough. We want to maximize kids' benefits. So if you are a special education student in Massachusetts, you're not just entitled to meaningful benefit at school, you're entitled to actually have your sort of educational progress be maximized to them as much as possible. And so that standard means something, the Rowley standard means something, but it doesn't mean quite as much in Washington as it does in Massachusetts. Least restrictive environment is sort of that principle we were talking about before, and that we want to keep kids as much as possible in regular schools. Now, it may not mean that a student who has disabilities is in all regular education classes, especially if they would really struggle. If the kid has a second grade reading level and they're in a U.S. history class where they're reading, 100 pages of U.S. history a week, it may be really tough. And so it could be that material in that class might be adapted to help the kids stay in the class, or it might be that they might need a special class to work with them on their sort of history work that has a special ed component or a special education teacher. Individualized education programs, that should be something a lot of you are probably already familiar with, my guess is. Those are the individualized plans that school districts create in order to implement special education. So it's the sort of roadmap, goals and objectives and services that a kid goes through every year. And they're revised each year. And then IEP meetings, how many people have been to an IEP meeting? Probably a vast majority of the people here.
And was it fully satisfying to everyone?
How many people have ever been dissatisfied when they went to an IEP meeting? Well, yeah, so there's some. I think.
And so what was the reason for the dissatisfaction? Just shout something out. I mean, what was it about it that you found unsatisfying?
They didn't want my child to have. They wanted to put her through the system, but they didn't want to give her the education part. They wanted her to like clean tables in the cafeteria or make cookies or something.
So a disappointment with what the focus of the discussion was about. My guess is that some of the hands that went in the air about dissatisfaction with IEP meetings also came up from people who attended them in a role as a school person. So I encourage those folks to speak up as well. A foster parent.
Yeah, the IEP team already decided if he was going to be approved or disapproved before he met with the parents.
So you felt that the decision had been made before the meeting about what the IEP should contain and address?
Yes.
Well, that's one of the great things about the special education statute is that it does say explicitly that these decisions have to be made with parent input. Parents have to be a partner in the process, and that it can include foster parents.
Right here.
Not all members of the MVP team are available, and they do not give appropriate time for discussions for parents or for those that are involved.
Just the logistics of fitting it in. The IEP team is supposed to be composed of a certain spectrum of people filling various roles, finding them, having it occur. Does it occur during school, in which case the teachers are pulled out of their regular class with substitutes having to cover, or teachers covering each other's class, or is it before or after school? It's just very hard to bring it together and have it come off with everybody who needs to be there, and then still have time to talk about the substance. Other thoughts over here?
Professionals using jargon that not everybody will understand.
Talking in tongues, like we're doing, right?
And also when psychologists or folks that are giving test results are explaining it in such a way that parents and sometimes other people at the table don't have a clue what they're talking about.
Discussion of test results and other technical terms in a way that doesn't really achieve understanding and communication.
Again, I don't want to make this sound like a promotional tour for our manual, but one of the things that we tried to do in the manual was take some of the alphabet soup of acronyms that people use and try to define them and lay them out so people can understand them better. And I think that is one of the big problems, is it is a very jargony language. And I think any special educators here in the room would agree that everybody starts talking about IEPs and MDTs and FAPE, and and eventually it can be very confusing to parents and to kids too. So let's move to the next thing. I talked a little bit about timelines for evaluation, and I want to go through that briefly. So from the time that a parent or a foster parent or a social worker or a school official makes a referral for special education, the district has up to 25 school days to decide whether to evaluate. And then if they decide to evaluate, if the team gets together with parental input, decides to evaluate, then there are 35 school days from that date to determine eligibility. So you can see it's quite some time, actually. I mean, we're talking about 5 weeks, really, at the first stage, another 7 later. You could be talking about 12 weeks to get from the referral to the actual evaluation. Now, my experience is that frequently school districts can do it quicker than that and try to. But those are the timelines you can hold them to. Is there another piece that comes if you hit? Yeah. So there's also 30 calendar days, not school days, but 30 calendar days once eligibility is decided to have an IEP meeting and develop the IEP for an eligible student too. And we talked about the fact that there's 15 days for response to a request for an independent educational evaluation. If you are working on trying to get a kid eligible for special ed, these are important timelines to understand. The other thing you should remember, I talked about earlier, is you can get an expedited evaluation if the child's out of school. So if there's a worry that the reason the kid's out of school might have something to do with a disability issue, you can move those timelines faster. So what are key protections under the IDEA if there's disagreement about special education? One of them is the right to notice. So anytime there's a change in placement or a decision not to provide special ed or a decision not to evaluate that you disagree with, you should be getting notice in writing about that. And of course, you've got a right as a parent to disagree. How many people in the room are foster parents? So under the old law, foster parents could be appointed as surrogate parents for kids and help make some of these decisions. Anybody here ever get appointed as a surrogate parent? No? One? Oh, great. So under the new law, foster parents actually, in certain circumstances, meet the definition of just parent. They don't have to be a surrogate parent. They can help make these decisions just because they're the custodians for the kid. So as a parent or foster parent, you have the right to request IEP meetings and to talk about disagreements. I mean, one of the things that I always say, and it may sound strange for a lawyer to say this, but you don't have to litigate every time there's a disagreement. I mean, it really is a good idea to try to clarify positions by getting together with the IEP team and talking about it. That's the whole reason that we have IEP teams, is to try to work on these kinds of things. And when you finally get to the point where even after everybody's talked about it, there's no agreement, there are lots of pretty good ways to try to resolve those disputes that are created by the statute and also our state law that implements it. So you have a right to formal dispute resolution, and one of those kinds of dispute resolution is mediation. There's a group called Sound Options, I think it's called here in Washington, that has the contract from OSPI to do mediation work between parents and school districts when there's a breakdown.
Anybody here ever gone through the mediation process on a special ed issue?
One, yeah. Without having to tell us necessarily the whole sordid story, did it go okay? Did the mediation help? Not particularly. I've heard that same thing from parents sometimes, that it doesn't always, for many of the same reasons that an IEP meeting can be dissatisfying, sometimes so can mediation. But it's usually a good first step to try when you're working towards resolving one of these problems. There's also the opportunity to make complaints to either OSPI, that's the Office of the Superintendent of Public Instruction. They're the kind of state organization that supervises the provision of special education and compliance with these laws I'm talking about, or the Office of Civil Rights, which is the U.S. Department of Education's Office for Civil Rights, which we talked about as sort of the arm of the government that's in charge of investigating 504 complaints. And then the last step is due process hearings, which are a little bit like the discipline hearings we talked about before, but slightly more formal. And if you get to the point where mediation and talking with the IEP team about the problem hasn't worked, you can actually ask an impartial hearing officer to listen to your case and make a decision about whether the right thing is happening.
And in this case, the impartial hearing officer is not in any way affiliated with the school group, the school board, the school district. In this case, the impartial hearing officer is an administrative law judge employed by state government and assigned to hear these cases, and so they follow it straight down the middle. It's very structured. School gets their time, student gets their time, witnesses are called, subpoenas can be issued. It's much more akin to a court hearing than the discipline. It's sort of on that spectrum somewhere in between.
And again, although it can be very helpful to get legal assistance in something like a due process hearing, and it makes sense to try to get it if that's where you're heading, the system is set up to try to help, and the ALJs, the administrative law judges that hear these cases, will try to help you if you're going to these hearings as a parent. I mean, you can bring an advocate, someone from an agency that's advocating for you, even a friend, to try to help too. And it can definitely feel really overwhelming to try to do it on your own, but I've talked to parents who've done it successfully, and I think if sort of you can get anything from what we've talked about today in this context of dispute resolution, I hope it's that you don't feel like you have to give up when you're having a dispute. Many times I talk to parents who say that they just didn't think there was anything they could do, that there was any way to kind of keep pressing the issue, that they just had to kind of agree with what the school was offering, and that's just not the case. There are definitely other steps you can take to kind of work up through the system and try to get a different kind of plan and services for your kid. Now, we have come to the end of our time, but before we go, I want to talk about the three most important things you should know about disciplining students with disabilities, because we talked about all the discipline rights regular education kids have in the context of discipline, right? Well, our special education students have all those rights too. They can have a hearing, they can challenge what happened, but they also have some additional rights, and these are the three main things. Students can't be punished, generally, for behavior that is the result of their disability. When a student gets long-term suspended or expelled, anytime there's more than 10 days missed of school, either cumulatively or at one time, the student should have the team, IEP team, should have a meeting to decide whether or not the child's behavior is related to disability. If it is, then the kid has to come back into school or into a different kind of program to try to get education again and get help. The other great thing is, even if it's not related to disability, federal law says that kids in special education have to continue to get a free, appropriate public education even when suspended or expelled. So even if you've been expelled or removed from school, districts are still going to have to work with kids and foster parents to try to make sure that they have the support they need to make it through their IEP goals and objectives and move from year to year. Students with disabilities have the right to receive education even if they're expelled from school. We just talked about that. The school administrator who's in charge of discipline may not know about the special needs of a particular student or the important steps that must be taken before imposing discipline. A lot of times the assistant principal who's in charge of making the decision about discipline may not know as much as the special education teacher or the foster parent, the caseworker about what's going on with a kid. And I hear all the time from families who there was no manifestation review, there was no kind of meeting after the discipline to talk about it. And so it's important for us to kind of remind people and push for systems to consider those factors when you're facing discipline. So that's all we have time for. If there are any other questions, or if we have a couple minutes that we can go in for questions, that'd be fine. But if not, the way I'd want to close is just say thanks for all the work that you guys do, especially the school districts and the foster parents and other people who are every day trying to help kids succeed and improve our grim reality of kids in foster care graduating from high school.
I'd say the same.